What is contributory negligence, and how is it different from comparative negligence? Contributory negligence and comparative negligence are legal doctrines that address the issue of shared fault in personal injury cases. They determine how the negligence of both the plaintiff, the injured party, and the defendant, the alleged wrongdoer, affects the outcome of the case. Contributory negligence. Under the contributory negligence doctrine, if the plaintiff is found to have contributed to their own injury in any way, even minimally, they may be completely barred from recovering any damages from the defendant. In other words, if the plaintiff is deemed even slightly negligent, they cannot recover any compensation for their injuries. This is a strict and harsh rule, and only a few states, including North Carolina, Alabama, Maryland, Virginia, and the District of Columbia, still follow this pure contributory negligence doctrine. Comparative negligence. Comparative negligence, on the other hand, allows a more equitable distribution of fault. There are two main types of comparative negligence: pure comparative negligence and modified or partial comparative negligence. In a jurisdiction that allows pure comparative negligence, the plaintiff can recover damages, even if they are mostly at fault. However, the amount of damages they receive is reduced by their percentage of fault. For example, if a plaintiff is found 80% fault, they can still recover 20% of the total damages. And there's modified comparative negligence. In states that follow the modified comparative negligence, the plaintiff is barred from recovering damages if they are found to be equally or more at fault than the defendant. However, if the plaintiff is less than equally at fault, they can still recover damages, but the amount is reduced based on their percentage of fault. Most states in the U.S. follow some form of comparative negligence rather than the strict contributory negligence rule. There are key differences, particularly the outcome for plaintiff. In contributory negligence, if the plaintiff is found even slightly at fault, they are completely barred from recovering damages. In comparative negligence cases, the plaintiff can still recover damages, but the amount is reduced based on their percentage of fault. And there's the degree of strictness. Contributory negligence is a strict rule with no room for recovery if the plaintiff is at fault. Comparative negligence is more flexible, allowing the recovery based on the degree of fault.